Good afternoon to my colleagues here in Florida and those of you tuning in from the East Coast, and good morning to the rest of you who are joining from elsewhere in the country. My name is Kwentin Eastberg. I'm the chair of the Capital Area section of the Florida chapter of APA. I'd like to welcome each and every one of you to our webinar today. The webinar is, of course, entitled Shining Light on Sunshine Laws and Other Public Records Requests, and is eligible for that ever elusive Law CM for any AICP members in attendance today. The event number, if you've got a pen, is 9300746. I will include a link to that in the chat box here shortly. Speaking of the chat box, a couple of quick housekeeping items before we get started. Any questions may be entered via the chat box. That will be up in the top or questions box in the top right corner of your screen. Staff will be monitoring that. However, we're going to hold off asking our panelists any questions until the end of their presentation, and we will answer as many as we can in that hour that we have. Also, this webinar is going to be recorded and will be available for future use as a resource. Lastly, I'd like to thank several folks for making this webinar a reality today. It actually started a few months ago at our annual Fall Social Section event. Our panelists were giving a similar presentation to our membership, and the success of that event actually catapulted to the presentation today. So I'd like to thank first APA Florida chapter for their support and resources to allow us to bring you this opportunity, also to National APA for their promotion of this event. But most importantly, I want to thank our panelists and Stearns Weaver Miller organization as a whole for allowing them to be here today, to step away to present with everyone. I hope you all enjoyed learning about this topic as much as we did. And without further ado, let me introduce our panelists to everyone. First, we have Erin Tilton. Erin is a shareholder in the Tallahassee office of Stearns Weaver Miller. She's an experienced litigator and represents private and public sector clients before local, regional, and state agencies, courts, and elected bodies on environmental, real estate development, and land use matters. In addition to her land development practice, Erin represents clients in administrative, circuit court, and appellate litigation on a variety of matters, including complex business, real estate, contract, and private property right disputes. She also has extensive experience in litigating issues under Florida Public Records Act on behalf of both private and public sector clients. And Erin currently serves as the board of directors for the Greater Tallahassee Chamber of Commerce, an immediate past president of the Tallahassee Bar Association, and on the Capital Region Leadership Council for Urban Land Institute. So welcome, Erin. And also we have Liz Ellis. Liz is also a shareholder in the Tallahassee office of Stearns Weaver Miller. Liz represents private and public sector clients in a complex real estate development, land use, and property rights matters. She has skills in developing and implementing litigation strategy, and as it relates to obtaining, challenging, and defending development approvals. Her experience also includes litigating eminent domain, inverse condemnation, and Burt J. Harris issues. In addition to land development, Liz also maintains a broad litigation practice where she represents clients on a variety of matters, including public records, constitutional law, and labor and employment disputes. Liz currently serves as president for the Refuge House of the Big Bend, as secretary of the Tallahassee Bar Association, and on the board of directors for the Tallahassee Women Lawyers. So without further ado, I would like to welcome them, and I'll turn it over to Liz and Erin. Go ahead and take it away.
Thank you so much for having us today, and good morning or good afternoon, depending on which coast you're located on. We're going to start off today by giving you an overview of both sunshine and public records laws in Florida. We'll start with public records law, and we're going to cover what constitutes a public record, who is subject to public records law, the maintenance and retention requirements under under Chapter 119, best practices for responding to public records requests, and also what to do in the event of a violation of public records law. You're going to see this lovely little disclaimer slide here that this doesn't constitute legal advice because we are attorneys and our law firm requires us to provide that to you. So in the event that you thought this was a private session in which you were getting legal advice, that is not the case, but call us if you need representation. And again, here is the overview of what we're going to cover on the public records side today. So let's start with a brief introduction. In Florida, the right to access public records is actually enshrined in our state constitution. It's in Article 1, Section 24, and states, as you'll see on the slide, every person has the right to inspect or copy any public record made or received in connection with the official business of any public body, officer, or employee of the state, or persons acting on their behalf, except with respect to records that are exempted pursuant to this section or specifically made confidential by this Constitution. That constitutional right is then implemented through Chapter 119 in the Florida statutes. Section 119.01 sub 1 provides that it is the policy of the state of Florida that all state, county, and municipal records are open for personal inspection and copying by any person. And Section 119.07, which is shown on the slide, provides every person who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so. So the right to access public records in the state of Florida is very broad. It should be liberally construed in favor of disclosure, and the only exceptions are those that are established by statute or by the Florida Constitution. So what are public records? Section 119.01112, and I apologize, this is going to start to seem a little bit like a statutory alphabet soup, but this is a law session, so I guess you probably expected a little bit of that. But Section 119.01112 provides a definition of public records as all documents, papers, letters, maps, books, et cetera, et cetera. You can see it there on the slide. Regardless of the physical form, characteristics, or means of transmission, made or received pursuant to law or ordinance in the connection with the transaction of official business by an agency. And so, kind of in furtherance of that statutory definition and based on subsequent construction by the Florida Supreme Court, in summary, a public record is anything that is first made or received in connection with the transaction of official business, and secondly, that is intended to perpetuate, communicate, or formalize knowledge. Public records can be located on anywhere, on any device, including work or personal computers, cell phones, other electronic devices. In fact, it's most often that those personal computers, cell phones, and other electronic devices are the ones that are they're truly problematic from the perspective of both locating and identifying public records. But whether a record is public is dependent upon the content of the record. It's not necessarily public just because it's located on a public device. So, for example, personal emails do not become public records just because they were sent from a public email account. But on the flip side of that, a record is not necessarily personal just because it's located on a personal device. And let's talk about a few examples of that come up frequently. There is no unfinished business exception to the public records law. You'll see that, I believe, on the slide. When determining whether a document constitutes a public record, it doesn't matter whether that document is in its final form. So any agency record that is circulated for review, comment, or information is going to be a public record, regardless of whether you've stamped it preliminary or draft. Those types of labels will not protect a document from becoming a public record. But in contrast to that, public employees' notes to themselves, when they're designed only for their own personal use, so remembering a list of items to do, or taking your own personal notes from a meeting so that you remember what was said and what the action items were, those do not fall within the definition of a public record because of that second part of the test, which is they do not perpetuate, communicate, or formalize knowledge, as long as they are not shared with another person. As soon as those personal notes are shared with a third party, a colleague, pretty much anyone in that context, they become public records because they are then intended to perpetuate, communicate, or formalize knowledge. Electronic records, importantly, are treated the same as written documents for the purpose of identifying public records. So your emails, Facebook posts and messages, text messages, Twitter posts. I think we need to update this presentation just about every 6 months for some new social media platform or new messaging app that's out there. But any communications from messaging apps as well will constitute public records, again, if they are made or received in connection with the transaction of official business, and if they're intended to perpetuate, communicate, or formalize knowledge. And finally, there is no blanket protection from public records law for communications between attorneys and governmental agencies. So we'll get into that, what's termed the work product exemption in a little bit more detail later, but it's important to know that there is no blanket protection for attorney-client communications.
All right, so who is actually subject to the public records law? And again, kind of reciting statutes here, you'll see on your screen section 119.011 subsection 2, which defines the agency under chapter 119. And it's a very, very broad definition. As you can see, it includes any state, county, district, authority, or municipal officer, department, division, board, bureau, commission, or other separate unit of government created or established by law, including, for the purposes of this chapter, the Commission on Ethics, the Public Service Commission, and the Office of Public Counsel, and this is an important part, any other public or private agency, person, partnership, corporation, or business entity acting on behalf of any public agency. So including entities acting on behalf of a public agency ensures that the public agency can't avoid disclosure of public records by delegating authority to a private entity, what would otherwise have normally been that public agency's responsibility. So when does a private entity, not otherwise connected with the government, become subject to the public records law? So the act of just having a contract with a public agency or receiving public funds is not by itself dispositive of whether a private company, which is not otherwise connected to government in some way, becomes subject to Chapter 119. So courts generally rely on two generic sets of circumstances when they're trying to determine whether a private entity falls under 119 in that acting on behalf of clause of that subsection I just read. So the first is the totality of factors test, and that applies when a public agency contracts with a private entity to provide goods or services to facilitate the agency's performance of its duties. So under this test, the courts generally consider a list of factors to determine whether there is a sufficient level of involvement by the public agency to subject the private entity to 119. Those factors include level of public funding at play, commingling of funds, whether the private company and the public entity have commingled their money, whether the activity was conducted on publicly owned property, whether the contracted services are an integral or material part of the public agency's decision-making process, whether the private entity is performing a governmental function or a function which the public agency would otherwise perform, the extent of the public agency's involvement with regulation of or control over the private entity, whether the private entity was created by the public agency, whether the public agency has a substantial financial interest in the private entity, and whose benefit the private entity is functioning for. So if the private company is functioning for the benefit of the public agency, that generally weighs in favor of disclosure under 119. The second test that courts determine whether a private entity is subject to 119 is the delegation of function test. And under this test, a contracting party that provides services in place of the public body rather than providing services to the public body, they are subject to the public records law. So are there any public entities that are exempt from complying with public records law? So yes, the short answer is yes, there are some. Courts have pretty consistently across the board held that the judiciary is not an agency for purposes of Chapter 119. There is a separate constitutional right of access to judicial records, however, not under 119. And access to those records is governed by the Florida Supreme Court. The Florida Bar is an arm of the Florida Supreme Court, so its records are also not subject to Chapter 119. Grand jury proceedings are privileged, and therefore any information records prepared for use during a grand jury performance or implementation of its duties, those are not subject to Chapter 119. And finally, the legislative branch, that Chapter 119 does not apply to that. There is a separate, again, similar to the judiciary, there is a separate constitutional right of access to legislative records. But the legislature can, by general law, adopt exemptions for specific records when there is a public necessity justifying the exemption. So let's talk a little bit about maintenance and retention. So the statute, Chapter 119 does not specifically designate a location for storage of public records, but they should generally, as a general rule, be kept in the buildings where they're ordinarily used. They may not be destroyed or discarded except pursuant to the applicable retention schedules developed by the Division of Library and Information Services of the Department of State, and those are all online on the Department of State's website. The department bases retention schedules on legal, fiscal, administrative, and historical value of various types of public records. Restrictions on the destruction of public records apply even if the record itself is exempt from disclosure. When agencies do destroy public records, they must document the destruction and that the records were retained as required by the applicable retention schedule. So you can't just say, oh, well, the retention deadline is passed, I'm going to go ahead and just destroy these and then later get a request from somebody and say, oh, it was destroyed. You're required under the statute to document the destruction of those public records once that retention deadline has passed. To the extent that public officers maintain public records in their custody, they're required by statute to transfer those records prior to leaving office. If the officer has a specific successor, the record should be transferred into the custody of that successor. Otherwise, the record should be transferred just directly to the Department of State. And that includes both electronic records and records located on personal devices. So if you have public records on a phone, on an email, and you're leaving employment with the public agency, those are required to be transferred over before you leave the employment.
Let's talk briefly about responding to a public records request. So again, Section 119.07(1)(a) provides every person who has custody of a public record shall permit the record to be inspected and copied by any person desiring to do so at any reasonable time, under reasonable conditions, and under supervision by the custodian of public records. The language "under reasonable conditions" in that statutory provision restricts the public agency's ability to regulate both the form of the public records requests it receives. So, for example, a person who requests a public record cannot be required to show a legitimate interest or meet other thresholds as a condition of access to the record. The agency can't require that the request be made in writing. That's one that we see a lot, or even that the requester identify himself or herself. Requests that are made by phone or in person have to be treated the same way as requests sent via letter or email. One thing I will note quickly, we're gonna talk more about what to do in the event of a violation and what litigation looks like in these circumstances. If you are the requester, you are not required to identify yourself. However, in order to have standing to file a lawsuit for a violation of the public records law, you have to have submitted a public records request as a prerequisite to even getting your foot into court. And so a requester that will not identify himself or herself is going to have a very hard time proving that they did in fact submit a public records request and are able to have standing to file a lawsuit in the event of a violation. The extent of inspection and copying that's required by the statute also limits the agency's required response. So in responding to a public records request, agencies are not required to reformat records, to meet the requester's needs. They don't have to create records that don't already exist. They don't have to respond to information requests or answer questions about information that is contained in the records. They don't have to perform research for the requester, and they don't have to respond to a standing request. So you can't just, as a requester, say, I want all of your emails regarding a specific project in perpetuity going forward and expect the agency to send them to you every month. You have to renew that public records request going forward. And they do not have to provide any records that post-date the date of your actual public records request. Importantly, though, if a requester asks for a record in a specific medium, so in a specific file format, or just say I'd like PST files for emails instead of PDFs. If the agency maintains the records in that format, they're required to provide them in the requested format. So you don't have to reformat your records to accommodate a public records request, but if you have the records in the format that they are requested, you are required to provide those. And finally, the fact that a record is also maintained by another agency does not relieve the custodian of the obligation to permit inspection and copying. This is one that we see agencies get into hot water with, with some frequency. For example, say it's emails between two agencies that theoretically each of the agencies should have their own unique copy of those the email correspondence. Agency A can't say to the requester, "Oh, go get them from agency B." That's going to be a violation of the public records law. As for the timeliness of the agency's response, this one is as clear as mud. The public records law does not contain a specific time limit to provide requested records, but Florida courts have determined that records must be produced in a reasonable time that would allow the custodian to retrieve the records and redact any exempt information. That's going to depend largely on the scope of the request, the type of records, and in some instances, the resources that the agency has available to them to respond. So the statute requires that the custodian promptly acknowledge the public records request and respond in good faith. That good faith response includes making reasonable efforts to determine from other officers or employees within the agency whether that record exists, and if so, where it exists and how it can be accessed. And based on fairly recent case law, which we'll discuss in further detail, if public agency employees and officials transact public business on privately owned devices or accounts, so their private iPhone or their personal email account, the agency has the affirmative duty in response to public records requests to do whatever is reasonably necessary to promptly retrieve any public documents from those employees or officials. So it is the agency's responsibility to go get the records that are on a personal device or in a personal email account. They cannot delegate that duty to the public official. It is the agency's responsibility. And an agency's unjustified delay in providing records, again, we don't have a great, bright line test for what unjustified delay necessarily is as far as the time frame at which point you have reached unjustified delay. It's all very context specific. But unjustified delay in producing records does constitute an unlawful refusal to provide access to public records and is a violation of public records law. In responding to public records requests, agencies are permitted to charge a requester for responding to the request if that request will require extensive use of agency resources. The agency can also require the requester to pay a deposit before the agency begins reviewing its records. Charges must be reasonable and have to be based on the labor or computer costs that are actually incurred by the agency. However, because the statute allows the agency to charge its actual costs, that agency is not required to charge the lowest hourly rate of an employee capable of doing the work needed. the agency can charge the rate and the labor cost of the personnel that was actually incurred by the agency. And where this one comes up with some frequency is, say your agency has outside counsel with a private law firm, and that outside counsel needs to be the one reviewing their records to determine whether any sort of exemption applies. Well, that outside counsel's hourly rate can be charged to the requester because that's the actual cost incurred by the agency. So you don't have to, give the attorney's records to the lowest hourly rate employee within the agency to do the review, or only recover that lowest hourly rate employee's time and effort for going through and identifying the records. It is the cost that is actually incurred by the agency is what they're entitled to recover. So in responding to public records requests, the agency also needs to review the records for any potential exemptions and to remove any potential confidential information. So let's talk just quickly about the difference between exemptions and confidential information. Exemptions have to be specifically listed in Florida statutes or under federal law. They cannot be judicially created. Courts cannot, rule that an exemption exists unless it is firmly planted in Florida statutes or federal law. Exemptions are supposed to be narrowly construed in favor of disclosure and have to be limited to their designated purpose. Again, the policy is that we want records to be access to be broad, and the agency's records should be open for inspection. The agency that claims the exemption has the burden of demonstrating that that exemption applies. So if the agency claims an exemption, it is required to redact the exempt information from the record and release any remaining portion unless the entire record is exempt, which is can be the case with certain types of records. The agency is also required to notify the requester that exempt records are being withheld, and it has to identify the specific statutory exemption at issue. That's designed so that the requester can assess whether or not it is a valid claim of exemption. You can't just withhold records and say they're exempt without giving a basis that can be verified for that exemption. And while the agency is not required to release exempt records, it is not necessarily prohibited from doing so in all instances. And that's going to be, we'll contrast that with confidential information, which we'll discuss in a second. Commonly encountered examples of exemptions, just to give you a few, include things like personal information of high-risk employees, home address, security systems information and blueprints, social security numbers, attorney work product, and mediation communications. I think the first three on that list are fairly self-explanatory. We're talking about information of high-risk employees, security system information and blueprints, and social security numbers. But I'd like to elaborate a little bit on attorney work product and the mediation communications that I mentioned. So attorney work product is a public record that is prepared by or at the direction of an agency attorney that reflects a mental impression, conclusion, litigation strategy, or legal theory, and importantly, that was prepared exclusively for civil or criminal litigation or for adversarial administrative proceedings, or in anticipation of civil or criminal litigation or adversarial administrative proceedings. Importantly, that work product exemption only applies until the conclusion of the litigation or administrative proceeding for which it was created. However, unlike attorney work product, written communications that are part of a court-ordered mediation proceeding are exempt, and the exemption does not terminate at the conclusion of litigation. Those records never become subject to disclosure. And of course, if you have questions about attorney work product exemptions and mediation communication exemptions, you'll want to discuss them with your counsel. Finally, let's talk quickly about confidential information. It varies from exempt information, and that confidentiality is created not by Florida statutes or by federal law, but by the Constitution itself, by the Florida Constitution itself. Agencies are prohibited from releasing confidential information unless they are ordered to do so by a court, there's consent by all the parties to the release, or there is a statutorily specified process in place. So contrast that with Agencies are not necessarily prohibited from releasing exempt records to the public, but when we're talking about confidential information or confidential records, they are prohibited from releasing those absent a court order.
All right, so what if there is a violation of Florida's public records law? So an agency's failure to sufficiently respond to a public records request can result in civil action being filed against the agency for failure or refusal to allow the records to be inspected. And Erin mentioned this earlier, and this might be really obvious, but in order to file a suit, a complainant has to actually have submitted a public records request to the agency. Mandamus is an appropriate remedy to enforce compliance with the public records law. You can also get injunctive relief where you have a well-grounded belief that there might be continuing violations in the future. You cannot recover monetary damages for a violation of the public records law. Recently, the public records law was amended to specifically prohibit agencies from filing declaratory judgment actions in response to a public records request to determine whether a record was confidential or exempt from disclosure. So when a lawsuit is filed, when a public records lawsuit is filed, courts are required to set the action for immediate hearing, and they are required to give the case priority over other pending matters. When there is an exemption at issue, the courts are required to conduct an in-camera inspection of the records to determine whether the exemption actually applies. And production of the records after the lawsuit is filed does not moot the issues raised. So if you file a lawsuit and the agency says, okay, fine, here, I'll give you the records, that does not relieve the agency of liability under the Public Records Act. So plaintiffs who file actions under the Public Records Act can recover the reasonable cost of enforcement, and that includes attorney's fees from the agency if the court determines that the agency unlawfully refused to permit a public record to be inspected or copied, and this is important as far as what the form of the request takes. The plaintiff provided the agency with written notice identifying the public records request to the agency's custodian at least 5 days before filing suit. So in that situation, obviously we spoke earlier, public records requests can be verbal, can be, really take any form. But in the event that a requester anticipates that a violation might occur and wants to institute civil action, they are required to provide the agency with that written notice 5 days in advance of filing an action. The pre-suit notice, however, is not required if the agency fails to prominently post the contact information for its records custodian in the agency's primary administrative building where the public records are routinely created, sent, received, maintained, and requested, and on the agency's website if the agency has a website. So in the event that the custodian you're unable to determine who the custodian is because the agency has failed to comply with that requirement, you don't have to provide the 5-day written notice before filing suit. So recent amendments to the public records law also added the possibility of fee recovery against a plaintiff who has filed a public records action and in favor of the public agency. But in order for the agency to actually recover attorney's fees in a public records civil action, they have to show that the public records request was submitted or a complaint was filed for an improper purpose. And an improper purpose means that the request was submitted or that the lawsuit was filed primarily to cause a violation or for a frivolous purpose. So it's a pretty high bar for an agency to meet and recover fees in that scenario. In addition to civil actions against the agency, violations of public records law can be assessed against individuals. So any public officer who violates the public records law commits a non-criminal civil infraction, which is punishable by a fine up to $500. And a public officer who knowingly violates the public records law is subject to suspension and removal, and also commits a misdemeanor of the first degree. Under some circumstances, a willful and knowing violation can result in felony charges. So Florida takes public records laws very, very seriously, and violations can result in some pretty serious punishment. Okay, so moving on to the second portion of our presentation, we are going to discuss the Sunshine Law. So basically going to cover what the Sunshine Law requires, who is covered by the Sunshine Law, when does it apply, and are there any exceptions? So Florida's government and the Sunshine Law, which is, shortened and called the Sunshine Law, it's codified in section 286.011 of Florida statutes. Article 1, section 24 of Florida's Constitution also requires that the public have access to public meetings. So the Sunshine Law is also enshrined within the Constitution. Sunshine Law essentially allows for the public to have access to the meetings of any public governing body. That includes all meetings at both the state and the local level where official acts are to be taken, or public business is transacted, or even just discussed. So I'm sure, as you can imagine, there are many different scenarios where the Sunshine Law applies, and there are many, many different ways that public bodies can violate the Sunshine Law. So let's dig into some of that. Okay, so what does the Sunshine Law require? It requires that the public have first reasonable notice of meetings. It does not require, I will note that it doesn't require that they have notice of the items to be considered at the meeting, although the Attorney General has advised that boards should make a reasonable effort to make those agendas with the items to be considered available to the public. There are also other non-Sunshine Law statutes and ordinances that might require an agency to post the specific agenda items in advance, but that is not a specific requirement of the Sunshine Law. So the phrase reasonable notice is not defined, and many jurisdictions take have many different methods of what constitutes reasonable notice. Courts generally have held that the type of notice depends on the particular facts of the situation and the board involved. So, for example, burying a notice inside a committee application and a calendar on like a random page of a board's website has been considered unreasonable, has been found to be unreasonable. On the contrary, posting a notice of a regular school board meeting on the public notice page of the school board's website and in a newsletter, that's been considered reasonable. So it's a really fact-specific inquiry. There is no clear-cut rule as to what amount of time or what specific location constitutes reasonable notice. Sunshine Law also requires that the meetings be open to the public and give the public a reasonable opportunity to be heard at those meetings. So generally, those meetings should be held in a place where the public has easy access, so not at like a country club or a place where certain people are prohibited from entering. They also should not be held in buildings that are difficult to access. Courts have also interpreted this requirement to mean that public agencies should avoid having lunch meetings because the public tends to not have the ability to get to those meetings as easily as, say, an evening meeting. And they've also interpreted that to mean that public agencies should not have meetings out of town. It's also recommended that if there is an anticipation that there will be a larger group attending, that the meetings be held in a large enough room to accommodate that large attendance. The final requirement under Sunshine Law is that minutes be taken, and those minutes ultimately become public records that are subject to Chapter 119. I will note that workshops are not exempt from this minutes requirement. Even if the meeting is recorded, which I know so many public agencies do nowadays, that doesn't count for purposes of Sunshine Law. You have to have written minutes. They have determined that a written transcript, so if you have a court reporter transcribing the meeting, that can satisfy this requirement of the Sunshine Law. All right, so who is covered by Sunshine Law? There are a variety of entities covered by the Sunshine Law, many of which are pretty obvious, such as, boards of county and city commission. There are some listed on the screen that are not always as intuitive. I'm going to go through those a little bit. So advisory boards and committees that are created by public agencies, those fall under Sunshine as well. There is one exception to the advisory board being subject to Sunshine Law, and that's an advisory board that is created only for fact finding and not in a recommendation type capacity or a decision making type capacity. For example, the standard planning commissions are subject to Sunshine because they are generally empowered to make decisions and make recommendations to the main board. So those are subject to Sunshine Law, and they are not considered just a fact-finding advisory board. Members elect who have not yet taken office are also subject to the Sunshine Law. However, an unopposed candidate, so if you have somebody who's running, say, for county commissioner, and they're running unopposed, they're not considered a member elect until the election has actually taken place. So they're not required to abide by Sunshine throughout their campaign. They are, however, required to abide by Sunshine as soon as that election has taken place and they become a member elect. Ex officio board members are subject to the Sunshine Law, regardless of whether they are serving in a voting or a non-voting capacity. They are still subject to the requirements of Sunshine. And finally, the governor and his cabinet members, when they are performing functions arising under the Florida statutes as opposed to the Constitution. So, for example, when the governor and his cabinet are exercising forms of clemency, like pardoning people, those are not subject to Sunshine. But when the governor and his cabinet are sitting on the board of trustees in the Internal Improvement Trust Fund, for example, which is a board created by the legislature, Sunshine does apply. Okay, so let's talk a little bit about application of the Sunshine Law. So the Sunshine Law applies to formal or casual discussions between two or more members about a matter which will reasonably come before them for a vote, which is extremely broad. It applies to in-person meetings, telephone calls, emails, text messages, and social media exchanges. So I always use this example. So if a county commissioner were to create a Facebook post talking about something that would reasonably come before him for a vote in the future, and another county commissioner replied to that post, that's a Sunshine Law violation. And this is often why you'll see the attorney's office sending emails to commissioners saying, please don't hit reply all to this email, because that in and of itself would be a Sunshine Law violation. The Sunshine Law does not apply to discussions with staff or attorneys. However, you should be careful about using staff or attorneys as a conduit. So the member can't say, for example, I want you to tell so-and-so about on the board that I'm going to vote this way. That's a Sunshine Law violation. It also does not apply to discussions with alternates. However, there is a caveat there. If the alternate is appointed to more than one board member to serve as an alternate for more than one board member, it can fall under Sunshine. So the rule of thumb here is to determine whether the alternate would ever be on the board with the person he or she is talking to. So if I'm an alternate and I'm appointed for Commissioner A only, I won't ever be on the board with Commissioner A. So I can talk to Commissioner A, and that does not violate Sunshine. But if I'm appointed to be an alternate for both Commissioners A and B, any conversations I have with either of them would fall under Sunshine Law because I could be on the board with either of them. Okay, so exemptions to the Sunshine Law. There are some exemptions, and they're very, very specific. So certain investigative meetings are not subject to Sunshine. That includes preliminary investigations by the Commission on Ethics, probable cause panels for certain agencies. Those don't fall under sunshine. Generally, however, and this is not for every single circumstance, but generally, once a probable cause determination has been made, the contents of the meeting are then made public. Litigation meetings are another exception to sunshine law. As Erin mentioned earlier, there is no blanket attorney-client protection for communications between an attorney and a board, but there are certain meetings and certain conversations that are exempt. So one meeting is related to litigation settlement negotiations or strategy sessions, and those are, I'm sure you've heard them called executive sessions or shade sessions, shade meetings. There are very specific requirements for those meetings. Those include that a court reporter has to be present and transcribe the meeting. The meeting has to be noticed. The attorney has to request the meeting in a public meeting. So the attorney has to say, board, I request that we hold a meeting to discuss litigation strategy out on X date. And the transcript becomes a public record once the litigation has concluded. There are also very strict requirements about who is eligible to be present at that meeting. And this, important to note, this exemption only applies to pending litigation. It does not apply where there is the threat of imminent litigation. So there has to be a lawsuit pending in order for this exemption to apply. Another exemption is collective bargaining strategy discussions. This only applies in the context of actual and impending negotiations. Once the collective bargaining process begins, the meetings are then subject to sunshine.
So we can spend a few minutes just talking about some of the hot topics and recent case law in this area, and then probably leave a couple minutes for questions at the end. But let's start with text messages. It probably comes as very little surprise to anyone on this webinar that text messages on personal devices are ground zero for public record violations, right? They're difficult to manage, they're difficult to track, and whether a violation is inadvertent, which happens frequently, or the other end of the spectrum could be intentional. It just is. We see a lot of jurisdictions struggling with what to do with text messages on these personal devices, and this, I think, is just one of those examples. So the case I wanted to talk about is Radiant LLC v. Nassau County, which is a recent case where the Fourth Circuit granted summary judgment in favor of the plaintiff, Radiant, on the public records portion of its complaint. So there were other issues involved in this litigation, but we're only going to talk about the public records piece. That complaint alleged that the county had indiscriminately deleted text messages without any consideration of their substantive content, and had failed to undertake a reasonable search for text messages that were requested by the plaintiff. So the county in that case initially took the position that the text messages didn't exist and provided none in its original response. Those text messages eventually came to light, in this case in connection with a former employee, and later through a response to a subpoena by the plaintiff on another former employee. And at that point, the county forwarded the messages to the plaintiff once they surfaced. But in its decision, the court outlined the plaintiff's burden in an action to enforce Chapter 119, and specifically said that the plaintiff has to prove the following. They have to prove they made a specific request for public records. Again, this goes back to you have to have made a public records request in order to be able to file a lawsuit. They have to show that the government agency received the request, that the requested public records exist, and that the government agency improperly refused to produce them in a timely manner. So using that, the court found that the requested text messages qualified as public records, and this is a quote from the decision, as any text message communications between the BOCC and county employees are public records if the agency employee or official prepared, owned, used, or retained the text message within the scope of their employment or agency. And that was based on the facts that the plaintiff showed were undisputed, and that no reasonable trier of fact could conclude that the county had properly responded to the public records request by producing those requested text messages in a timely manner. This is where the court specifically gets into some text message specific issues that I think are indicative of what we're seeing in other jurisdictions as well. The court held that the routine and indiscriminate destruction of text messages, regardless of the content of each message, violated Section 119.021 Florida statutes, which is the retention requirements. Because according to the Department of State's retention schedules, which Liz talked about earlier, the county should have retained these text messages for 3 or 5 fiscal years, depending on the classification of the records, which is going to be based on the actual content of what was in those messages. The court further held that the county's approach to the retention of text messages was unreasonable and inconsistent with the goal behind the Public Records Act. And that despite the text being retained by 2 of the county's former employees, the duty to produce those records was on the part of the individual government officials to preserve public documents and records. That's not somehow altered, the court said, because those items are stored on their private account or privately owned device. And in such situations, an agency still has a duty to produce public documents in response to a valid public records request, no matter their location. The court did acknowledge, though, that if employees or officials have no individual responsibility under the Public Records Act to retain those public records stored on private devices in accordance with the published retention schedules, then there is no way to ensure that a governmental agency will be able to fulfill its obligation to retrieve those public records in response to a request. So the court just highlights hits the nail on the head. This is the exact issue with text messages on private devices is, yes, it is the agency's responsibility to produce those records, but it's very difficult for the agency to even know that those records exist. And this is an issue, I know I'll pick on Nassau County a little bit here just because of this published decision, but this is not an issue that is unique to Nassau County, to be clear. We see it in jurisdictions all over the state, really, really struggling with these issues. So ultimately, the court held that if public agency employees and officials transact public business on their privately owned accounts or devices, then the agency has an affirmative duty in response to the public records request to do what is reasonably necessary to promptly retrieve any public documents from those employees or officials. And in this case, the county did not. The court also concluded that automatically deleting text messages after 30 days, which plenty of us probably have a similar setting on our electronic devices, although if you're subject to public records law, you should not. But the automatic deleting after 30 days or arbitrarily clearing space from a personal device without concern for the content of those messages is inconsistent with Chapter 119. And thus the court held that the plaintiffs were entitled to summary judgment that the county had violated public records law in that case. But again, I want to make sure I'm not picking on Nassau County too much here, because for every circuit court or appellate decision that we see on a public records issue, there are a dozen more cases that are either settled without ever reaching a final judgment from the court, so it wouldn't be any kind of published opinion on the issue. And in the last few years in particular, almost every case we've seen has centered around text messages in some form or fashion. One that we were involved in recently involved an elected official who had a personal flip phone to communicate with constituents about public business in a small community, which you can see how that would happen, but would communicate with constituents about public business over text message with some regularity. And then the commissioner, when he went to upgrade his cell phone, walked into, say, Verizon, handed his device across the counter to the carrier and accepted a new device in exchange without ever transferring any of the text messages that were stored on that phone. And because of the type of phone and the limitations on the technology, those weren't being backed up anywhere. They were essentially lost as soon as the carrier went and wiped the phone. We've seen cases where elected officials have unknowingly had iPhones set to delete messages within, say 30 days. And so please make sure you check all of the settings on your devices, and make sure that you're not inadvertently deleting messages that you may not even realize are being deleted. And so it's definitely best practice not to communicate about public business on personal devices, but that's understandably not always a realistic option. And so it's really important for agencies to develop and implement policies that somehow take those records on those private devices and bring them into the agency's control, so that they can be located in response to a public records request. And we've seen examples of this throughout the state where policies are starting to be implemented. Again, first and foremost, please don't use your private phone to conduct public business. But if you do, we've seen programs where the person who has custody of that, say, text message, is asked to then forward it into the agency's email system. So it then becomes part of the records that the agency can manage. We've seen similar software programs that do things to that effect. But again, the human element of the individual who is doing the text messaging, or who has custody of that private device, there's really no way to avoid them having to participate in that process. And so that interface between the agency and its employees, elected officials, anybody who is really conducting business on the agency's behalf, is really important to make sure that everybody understands how those records are to be maintained and how they get into the agency's custody. I think we only have a couple minutes left, so I'll pause here, but suffice it to say, we've got public records cases. Probably not surprising to anyone here that Facebook has been a popular one in recent years as far as interesting sets of facts for what has to be produced in response to a public records request. And the last one, email systems and security measures. As you're doing IT upgrades and having all kinds of security filters and those types of things on your email systems, it's important. It's important to remember that we want to filter out anything that's spam, but we also don't want our filters to be so strict that they filter out things that we ought to be retaining and producing in response to a public records request. So, and with that, I'll turn it back over, and I don't know if we have a couple minutes for questions or not.
Sure. Thanks, Erin. Liz, is there a slide with your contact on there just in case?
Yes.
I don't think you want to just forward to that one so folks can have that at the very end, and I'll rifle through a couple questions. I know we've got just a couple minutes left. There's a couple in here that were really, really interesting, I thought. You were talking about when public records are requested, you don't have to change the format. Does this apply to translation as well if you're translating into a different language?
I don't know that I have seen that specific issue, but what I would say, just based on what the statute requires and the cases that we have seen, I would be very comfortable making an argument that you do not have to translate records into another language in order to provide them for a requester. There may be ADA requirements that somehow impact that, but for purposes of Chapter 119 in compliance with public records law, you just have to provide what you have.
Right. General rule of thumb is produce it in the way that it's normally kept. So if it's kept in another language, you produce it in that language. I would completely agree with that.
The next one is regarding payment for cost to obtain documents. Do you have to pay if they don't send what the requested documents? Let me rephrase that. So, do I have to pay if they don't send me what I requested and it is the wrong document? If you got a bill for the county for a fee, but then told them to refuse to pay because it wasn't the provided document that they requested, and I never heard back. I was just wondering if there was precedence or standard procedure for such a scenario.
So I'm assuming this is a scenario where they, like you said, you got an invoice for a specific records request, went ahead and say put the deposit down. The county or city, whoever, whatever jurisdiction it is, responded with records that maybe weren't responsive to the request. And so the question is,
Correct.
can I get my money back? In that one, I don't know that I have ever seen like any sort of published opinion on that issue. What I would tell you is if you're going to be writing a check for some for substantial use of resources, I would make sure that your search terms are nailed down, or that you have some sort of parameters on what it is that's being provided to you on the front end, so that you do ensure that you get what it is you're actually asking for. But in that situation, I would probably just say, hey, this isn't what I asked for, and here's, can you go back and give me what I actually need here? I don't know that there's necessarily any legal basis for a refund, but with the exception that if they're not giving you what you requested, that in itself is a violation.
Okay. And I guess the last one, and then we're at time, but what is the remedy for a scenario where the agency should have the records subject to disclosure but can't or won't disclose them?
How do you know that they should have them? I guess would be my question. It's difficult to know what you don't know, right? It's when you request something, you assume an agency has possession of it, but without real knowledge that the agency actually does have possession of a record, it's very difficult to prove a violation. A lot of times we run into this when agencies and we get lucky because agencies often communicate with each other, right? So you serve the same public records request on one agency and another agency, and one agency gives you what you expected to see and the other agency does not give you anything, and then it's easier to show that there has been a violation.
But if you submit a public records request and the agency does not have the record, I would argue, and I'd be very comfortable arguing, that a good faith response to your request is to say, we do not have any records to provide in response to your public records request, or we do not have any records in our possession, that are identified in your public records request. So I don't think the agency can just put you in a loop of, you've asked for something, you can't prove that they have it, but they should, and then you kind of end up doing this dance back and forth. I think the good faith response is we don't have any records responsive to your request.
Well, and with that, I see we're over time, so I do want to thank both Liz and Erin for your time here, and for those that are on the call, one final reminder for your CM event, if that's what you're here for, the number for that is 9300746. A link is in the chat. And then with that, I want to thank everyone again for attending. Thank you all in Stearns Weaver Miller for hosting. And I get a lot of thumbs up and applause in the chat here. So everyone's been really excited.
Thank you. My day needed that.
Oh, it's still coming in. It's like flying through here.
Appreciate it.
Appreciate everyone. Have a great holiday season. We'll hopefully do this again sometime in the future. Take care.
Thank you.
Thank you.